The court will now consider whether a state can put in place a Second Amendment Preservation Act, which has the purpose of making a state a two-way sanctuary.
The revised version of the Second Amendment Preservation Act is moving through the Senate, but it's facing renewed opposition.
The court turns down Missouri's bid to revive a law that declares various federal gun restrictions unconstitutional.
It has already been approved by several Senate committees. However, as we saw on the Senate floor today, not everyone is on board.
8 justices just voted against Missouri's gun law. 1 justice stood completely alone. But buried in this ruling is a statement from 2 conservative justices that the media completely ignored. And it might have just handed gun rights supporters a secret weapon that could reshape Second Amendment enforcement across America. So here's what everyone got wrong about this Supreme Court decision. The headlines screamed defeat. They said Missouri lost. They claimed the Second Amendment Preservation Act was dead in the water. But when you actually read what Justice Gorsuch and Justice Alito wrote in their statement, you realize something extraordinary is happening beneath the surface. This isn't a simple loss. This is a legal chess move that could fundamentally change how states resist federal gun enforcement, and the implications stretch far beyond Missouri's borders. Let me break down exactly what happened, why Justice Clarence Thomas was the only one willing to publicly support Missouri, and, most importantly, what this Gorsuch-Alito statement actually means for gun owners right now. Because what's really going on here is not what anyone is telling you. The Supreme Court just issued an 8-1 decision denying Missouri's emergency request to protect their Second Amendment Preservation Act. Justice Clarence Thomas stood as the lone vote supporting Missouri's stay application. Chief Justice John Roberts joined 7 other justices in denying the state's request. Now, here's the first thing you need to understand about how this actually went down. This decision came through what's called an emergency application. That means Missouri never got a full hearing, no oral arguments, no extensive written briefs, no opportunity to fully present their case before the highest court in the land. They were essentially asking the Supreme Court to hit the pause button while their appeal works its way through the system. Missouri filed this application after getting rejected twice. First, the district court said no. Then, the 8th Circuit Court of Appeals said no. Both lower courts refused to pause the injunction against Missouri's law, forcing the state to take their last shot with the Supreme Court. But here's what makes this so fascinating. The court did not rule on whether Missouri's law is constitutional. They didn't decide if the state was right or wrong on the merits. All they decided was whether to temporarily pause the lower court's injunction while the appeal continues. And they chose not to intervene, at least not yet. When 8 justices agree on something in an emergency context, it usually signals they want the lower courts to fully develop the record before stepping in. They're essentially saying, let this play out a bit more before we get involved. But there's a massive twist to this story that completely changes how this order should be interpreted, and it involves what 2 justices specifically wrote about private citizens. To understand why this case matters so much, you need to know exactly what Missouri created with this law. Missouri passed House Bill 85 in 2021, and this legislation is unlike any gun rights law that had ever existed before. The law declares that certain federal firearms regulations exceed constitutional authority when they restrict the manufacture, ownership, or use of firearms within Missouri's borders. But this wasn't just a symbolic resolution politicians could wave around during campaign season. This law created real, enforceable penalties against state officials who cooperate with federal gun enforcement. The legislation emerged after years of growing frustration among Missouri lawmakers who believed federal agencies were systematically overstepping Second Amendment boundaries. Between 2008 and 2021, the ATF proposed or implemented more than 15 major regulatory changes affecting firearms. Bump stock bans, pistol brace regulations. The list kept growing. Missouri lawmakers decided enough was enough. Here's what the law specifically prohibits. No Missouri state or local officer can participate in enforcing federal gun laws that the state deems unconstitutional. They cannot provide personnel. They cannot provide facilities. They cannot provide equipment. They cannot provide any resources whatsoever to support federal enforcement actions. Think about what this means in practice. If federal agents want to enforce certain gun regulations in Missouri, they have to do it entirely on their own. No help from local police. No assistance from state troopers. troopers, no cooperation from county sheriffs. The federal government is completely on its own. The law also extends protection to Missouri gun manufacturers and dealers, shielding them from federal regulations that Missouri believes exceed Second Amendment protections. And this is where things get truly revolutionary. Missouri didn't just refuse cooperation. They built an enforcement mechanism that terrified federal authorities. Here's where Missouri got creative. The law allows any private citizen to sue state officials who help enforce federal gun laws. Not file a complaint, not ask for an investigation. Actually take them to court and win money damages. The minimum penalty is $50,000 per violation, and there's no cap. Let that sink in. A small police department with 20 officers could face over $1 million in liability from a single incident, and that's before attorney's fees, which the law also allows. Missouri essentially privatized constitutional enforcement. This creates an impossible situation for law enforcement officers across the state. Every time a federal agent asks for help, officers now have to decide whether that cooperation could cost them $50,000 personally. And that's exactly the point. Missouri wanted cooperation with federal gun enforcement to become legally radioactive. But Missouri didn't invent this strategy. They copied it directly from Texas Senate Bill 8, the abortion law enforced entirely through private lawsuits. When abortion providers tried to block that law, the Supreme Court shocked legal experts by ruling that courts couldn't stop it pre-enforcement because the state wasn't enforcing it. Missouri's lawyers paid close attention. If that structure could protect abortion restrictions, they believed it could protect Second Amendment rights too. The federal government didn't agree. They sued Missouri in 2022, arguing that the law violated the Supremacy Clause and amounted to unconstitutional nullification. A federal district judge agreed and issued a sweeping injunction blocking the law entirely. Missouri appealed, and that's how this case ended up at the Supreme Court. Justice Clarence Thomas was the only justice willing to grant Missouri's emergency request. While he didn't write an opinion, his vote speaks volumes. Thomas has long supported both state sovereignty and strong Second Amendment protections. He has repeatedly argued that states cannot be commandeered into enforcing federal law. That principle sits at the heart of Missouri's argument, but the fact that Thomas stood alone tells us something important. Even justices who joined him in major Second Amendment victories weren't ready to support Missouri at this stage. And then came the statement that changed everything. Justice Neil Gorsuch wrote it. Justice Samuel Alito joined it. They voted to deny Missouri's request, but they added a crucial clarification. Gorsuch explained that the district court's injunction only binds Missouri, its officers, agents, and employees. That's it. The injunction does not bind private citizens who were never parties to the lawsuit, and any attempt to extend it to private citizens would exceed the equitable powers of federal courts. He cited the Texas abortion case directly. This is enormous. It means Missouri's enforcement mechanism may still be alive. Private citizens are not barred from filing lawsuits under the law. The state itself can't enforce it, but individuals can. That transforms this ruling from a defeat into something far more complicated and potentially far more dangerous for federal gun enforcement. Here's how this could play out in real life. A Missouri citizen learns that a local sheriff's department helped federal agents enforce a gun regulation Missouri considers unconstitutional. That citizen files a lawsuit under the Second Amendment Preservation Act, seeking $50,000 per officer involved. The sheriff argues the federal injunction blocks the lawsuit, but Gorsuch and Alito just suggested that argument fails, because private citizens aren't bound by the injunction. Now the federal government faces a nightmare scenario. They can try to intervene in dozens or hundreds of state court cases across Missouri, or they can attempt to expand the injunction, something Gorsuch just warned against. This is the same whack-a-mole problem created by Texas's abortion law, and it's exactly what Missouri intended. The case now returns to the 8th Circuit Court of Appeals for full briefing and argument. That process will take months, and depending on how it plays out, this case is almost guaranteed to come back to the Supreme Court, this time for a full ruling on the merits. What we're watching is a direct clash between state sovereignty and federal supremacy, with the Second Amendment right in the middle. And the outcome could reshape gun rights enforcement across America for years to come. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.